Oh.
It's been 12 months since acquittal, and so much has passed us by. Such a scattering with evidence, and some blatant flat-out lies. In a special new press sector, and Hank Breeden is his name. He is a dirty Boston lawyer, and his arguments are lame. He's trying to squash all of our experts, as he has no case to claim. He should have won an Oscar medal to convince the court he's sane. He can lie without a conscience and keep that smirk upon his face. I bet he wears those silky undies, the ones with that G-made lace. And Judge Beverly Academy is so biased for the state, is waiting through 100 motions in a rush to seal my fate. So you can bring in Massachusetts, cause we all ain't got no quit. And we all know that the truth is my car is not the thing John hit.
Hello, hello, hello.
Hidey ho, heedy hi, hidey ho.
Good morning, even. They have a jury.
Yeah.
Finally.
They decided to take a break. That's nice of them. Lovely.
It is.
You just, you just do you. You just work to your own, beat your own drum, so to speak.
But today is a motions hearing.
Good morning, madam.
Hello, Teresa. So we're going to watch part of the motions hearing or all the motions hearing, depending on how long it takes.
Good morning, Brooklyn.
Hey, Brooklyn. Brooklyn looks so good in blue, doesn't she?
Well, after you got off last night, Dan and I were having a bit of a chat about the defense and prosecution strategy. So we're going to have a bit of a chitty chat about that as well, like try and break it down a bit and understand where they're coming from and what they've got backing them in their strategy type of thing and what they've got going against them. Does that make sense?
Yeah, absolutely.
Yeah. Because I've heard a lot of people have really poo-pooed the third-party culprit defense. And as everyone knows, the defense really doesn't have to do anything. Burdens on the state. But they have put themselves into a position where they do have to prove something.
I think this is like the one case out of millions where they kind of do. Yeah. They kind of do have to prove a negative, if you will.
So people have said, what I've heard is that, she's changing her strategy. Like once she goes for, first she started with this and now she's going with third party culprit. And it's like, well,
she does do that.
You have to put forward a defense and you've got to work with what your strongest features are, and halfway through the trial, they learn about the ARCA witnesses. So,
right, because they weren't allowed to interview them ahead of time.
And then between then and now, there's been apparently a whole heap more evidence that's been released. And so that's why there obviously is more evidence that points towards that actual line of defense. So why is it an issue that it's not like she's going from innocent to guilty? It's purely the line of defense. Does that make sense?
Yeah, I think it's more of it could have been this, or it could have been this, or it could have been this. There's no way it was me.
Yeah. It's like going from first degree to second degree. Like you thought you had enough to go to prove intent, but no, you've dropped it back because you didn't. And I don't see any issue with that. There's no point over charging someone because you don't meet the burden. So,
right, but that happens all the time.
Yeah, true that.
Yeah, they overcharge people all the time in hopes that they'll take a plea.
Yep. And so, of course, Jodie started working with this AI, asking it.
Cheeky, shut up. She had a twin sister. She would blame her.
Good day. Sorry, cheeky monkey, I didn't see that.
Good day.
Good day, mate. How you fucking doing? So, yeah, I've been playing around with this and then got down a rabbit hole and yep. But I found some really good stuff. I found out I have proof that Karen Reid did not say I did it. I hit him.
Yeah, well, that didn't come out until trial day. It didn't come out until then. So
that was just after.
Yeah, that just pulled out.
Here's why.
Okay, what you got?
Ms. McCabe, I want to go back very briefly to something you said just before we broke, and that was in respect of the statements that you attribute to my client out of the scene. You said, well, there was an officer possibly asking questions, or it could have been a female EMT, and I wasn't answering questions about that, correct? Hence, you didn't say, I hit him, I hit him, I hit him.
Can you be clear on your question?
Let me rephrase that.
Not really.
Before we broke a few minutes ago, you had said, the reason I didn't say, I hit him, I hit him, I hit him, is because I was never asked. And the subject never came up about what an officer asked her when she declared that. So I just didn't offer it. And then you said, or it could have been an EMT.
Yes, I'm unclear who was there.
Isn't it true that at the grand jury, the question that was posed to you, and this is counsel page 208 of the grand jury, the question that was posed to you is, quote, so what happens next with yourself, Ms. Roberts, and Ms. Reid? And your answer was, so there are different, police officers getting statements from us.
That's better.
At one point, I'm standing with Ms. Reid, and she's saying, did I hit him? Could I have hit him? And there was, I believe, an EMT, a female, standing right next to me and listening to her yelling, did I hit him? Could I have hit him?
What?
Is he dead? Is he dead? Is he dead?
I didn't hear.
It was pretty much non-stop. Remember that testimony?
I do.
So in point of fact, you were answering the direct question about what happened in front of the police officer and the EMT, correct?
There were multiple police officers and multiple EMTs present.
So now this is another police officer and a different EMT.
I'm not saying that.
Okay. But nowhere in this did you say that she declared the words, I hate him. Correct? We'll agree on that.
Correct.
Bring it, Massachusetts. Fucking bring it. She did not say it.
And the closing arguments is
out
another
of the horse's mouth.
You were wrong for that.
Sorry. Yeah, I was.
The closing arguments too is another example of that. He says, what's his name? Lally says it 4 times. She said and he goes, she said exactly. I hit him. I hit him. I hit him. I hit him. And he said it 4 times. No,
and it's not true. It's not in the testimony.
Nope.
Not anywhere. And then I went on another little deep dive to do with Hank and Whitey Bulger.
Yeah, true, Brooklyn. Oh, you got something with Hank and Whitey Bulger?
I have a little something, and it's a shout out to Boozy Beauty. Boozy Beauty.
Bougie Beauty? Okay. Shout out Bougie.
Get a conviction. There is one thing you might see out of a very pathetic district attorney.
And we thought we were going to expose a little bit of government corruption.
And that is to hire someone who...
Bit of context. This is when Hank Brennan was defense attorney for Whitey Bulger. This is his interviews and commentary. from.
If you don't know who Whitey Bulger is, he was a mobster.
It's explained. It's a couple of minutes, but yeah, it's good.
Who has a bone to
Gives a
pick.
perspective.
Little did we think that the government would expose more corruption than we ever could have.
Really?
I remember seeing this headline stating, District Attorney's Office taps Whitey Bulger's former attorney to prosecute Karen Reed the second time around. And I've sat on this info, but now it's gotten to the point where I've been watching Hank Brennan and the way...
This came out over a month ago as well. Just so you know.
that he, I don't know, doesn't file affidavits, so he isn't held accountable in court, i.e. he doesn't actually put any facts to his statements. And after what happened last Tuesday, I thought I should throw this out there.
The answers to who is accountable and who's responsible. That's why we called members of the FBI that the government chose not to call. People we had never even spoken to before, to get them on the stand and try to find out answers. That's why when we cross-examined witnesses, we didn't shy away from areas. We wanted to know, we knew the community wanted to know, and we knew that many of the victims' families had to know. And we did our best. At many points, we were stopped over and over again. We were prevented from bringing out information that our members of the public, our citizens, are entitled to know.
I'm sure most of you remember at least the minuscule aspects of the Whitey Bulger case. A former Irish mob boss who was on the run for decades, had some connections with the FBI. He was eventually found in California in an apartment and yada, yada, yada. And if you didn't follow his trial, they basically were stating that he wasn't a paid informant. He's the one that paid the informants? Now, it was an absolutely interesting defense, but what I will state, and what I'm never ever going to disagree with, that what happened to Bulger and the feds and all those families were so fucked up. But at the end of the day, Bulger did what he did, like, period. From this case, and from having personal experience with Whitey Bulger, Hank Brennan is throwing axes right at Karen Reed's defense. It is simply because he is biased to the fact of a federal investigation.
It was important for the jury. It was important for the community. It was important for the public to know how the federal government operated during that time and how they're operating today.
I can only imagine when Norfolk County District Attorney found out that the feds were involved in investigating the murder of Boston police officer John O'Keefe, where they hired their own experts to see what the fuck went on. Is it possible that that actually happened, that Karen ran into John with her Lexus SUV, and it was proven by biomechanics and physics and science that it's physically not possible? He needed something desperate. And in comes Hank Brennan.
Well, you know, we expect our criminals to commit crimes. That's what criminals do. We don't expect that from our law enforcement.
But also to note, a lot of people are missing this one very specific point. Hank Brennan, as one of two main attorneys for Whitey Bulger, also was very close to Bulger's family. Whitey Bulger's brother, William Bulger, was a state senator from 1970 until 1996. Michael Morrissey was a state rep until 1990, became a senator in 1992, all the way up until the year 2000, where he then became Norfolk County's district attorney. Whitey Bulger's brother served with Michael Morrissey. That right there.
What?
The government pinned their hopes on these predicate offenses, in many cases, upon witnesses who we thought had an absolute lack of credibility, an extraordinary motive to lie, and were not guides that a reasonable person could follow to help find a conviction. To ask a public or a jury to trust in whole witnesses that had such promises and inducements and such motives to lie, in some ways that's reflected itself in the verdict.
I have personally watched interview after interview of Hank Brennan pre, during, post-trial, and also all the interviews that he did post Whitey Bulger's death, including a lawsuit that went up to the federal Supreme Court. This man, in interviews up until 2022, was stating his disdain for the FBI.
And anytime we saw a fallacy or a fabrication, we try to check it and counter it and show that it wasn't true. Why do I suspect it was so important to the government? Well, part of it was because of
Such a nerd.
reputation and pride and
Shut the
public
fuck up,
relations.
Hank.
He has made it known how much he hates the feds.
There's more accountability, and our government needs to answer the hard questions that have been raised by this case. There are answers that are needed by the families and the public, that the families and the public need to keep pushing for. And so we've tried our best, and we'll keep trying the best we can. And now it's time for the public to try as well.
And now he's overseeing a trial where there are federal experts that are trying to prove Karen Reed did not hit John O'Keefe with her Lexus SUV. What do you think he's going to do with that information?
Most important part, to help show the role the government played in this entire conspiracy.
Hank Brennan, as a special prosecutor, hired by the Norfolk County District Attorney, is going to do everything in his power to say that ARCA needs to be excluded. He can't say that they're not qualified, because they were already qualified in the previous trial, as well as if they want to do the voir dire, they can absolutely do that. So they're qualified. You can't say that they're not medically qualified, because they're not testifying against John's specific injuries, specifically the head. So what is he going to do? He's going to try to exclude them via the defense by discovery purposes. I believe now that Hank Brennan was hired not to be a cheapened special prosecutor because ADA Lally fucked up so bad. No, I believe special prosecutor Hank Brennan was brought on simply because he hates the feds so much, and he's going to try everything in his power to try to make sure Karen, via discrediting the federal investigation, goes to jail.
The depth of the corruption within the Department of Justice in that time, all the way to the top, is a story that should and hopefully still will be told.
And that, my friends, is a prosecutor trying to get a conviction, not the truth.
Wow.
She could not have said it any better. If I could not have said it any better than if
she broke that down good.
Spot on.
I didn't know that there was a tie there. Whoa.
Whitey Bulger's father and Morrissey worked together but he's even at the end there, he's talking about corruption all the way up to the top, yet he's denying it. Now, the next case as a prosecutor,
and he did Whitey Bulger. I mean, Whitey Bulger was not a great person. We all know that. But what he allowed to happen to him was just.
Yeah, but my point is that his strategy, like the last trial that he was at with Whitey Bulger,
he's doing the same thing.
Exposed a heap, more than they could even imagine, of police corruption right up to the top. And now he's in the prosecutor's seat. That's not an option.
And that's supposed to be his job, is to expose the truth, not bury it. But that's what he's doing. Exactly what he's doing.
So it looks like 93.93.
Yeah. All right. So where did Mr. Dan go? Is he still playing with his sound?
Yes.
Yeah. He's playing with his sound.
Dan, do you want to talk a little bit about defense? Or not defense, prosecution?
No, well.
Oh, I'm sorry.
I know I was supposed to focus on defense tonight, but I got carried away on.
My bad.
No, it's not you. It's me. What?
Did you find the video?
Yes, I've uploaded it. Hang on. One memento.
Somebody, not naming any names, it's this person, asked me if we could play the video of Karen backing up and hitting John's car.
And you can play that one. I've got
okay.
I've got one that explains the tail light.
Okay. Well, I think. Well, isn't this how she got the crack?
Yeah, you do. Okay. You do that one while I'm looking for this one. I'll upload it.
You always had the crack.
Your volume is really low.
All right, here it is. Here it is. Oh, that's the officer response. Okay, here it is. So this is her backing up and hitting John's car. Or that's what the newscaster says. Here we go. Here we go. I'm hitting add to stage. Okay, there we go.
After 2 days of trying, the lawyers in the Karen Reed murder trial just outside of Boston, they got themselves 11 of the 16 jurors.
Hey, Irish. How are you?
And if those people have not been following this case, they have no idea what they're in for.
Yeah. No.
Karen Reed is the financial analyst and the college professor who's accused of murdering her boyfriend, John O'Keefe, a longtime Boston police officer. It happened back in January of 2022. And ever since then, the investigators have been building their case against her. But the doubters have been getting louder and louder. The investigators say that she backed over her boyfriend after a drunken argument and then left him to die in a snowbank outside of a house party. But Reed's defenders say the evidence does not add up.
Nope.
They say the victim's injuries aren't even the kind you get from vehicle impact, and they claim the investigators planted evidence at the scene, evidence like fragments of a broken taillight from Reed's SUV. None of those defenders is more convinced than that of my next guest. Sean McDonough is a DEA
Sean McDonough.
special agent.
I didn't even know that
who's investigated this case.
How old is this?
Pretty much full time for a year now.
I don't know.
He says he can prove that Karen Reed's taillight was completely intact
last year
after the alleged hit and run happened. Take a look at this video from the doorbell cam. It was taken at 5:03 a.m. And 5:03 a.m. is hours after Reed and O'Keefe parted ways.
Yep.
You can see right there in the circle that Reed's taillight is right where it's supposed to be.
Yep.
In her Lexus SUV. I want to welcome to the program.
Funny that.
Sean, that video is sort of jaw-dropping. It's kind of like the Perry Mason.
What, Dan? Dan, you need to turn your volume up. You're really low. Let me see if I can edit.
For some reason. I don't know why.
Oh, here. I'll edit it. Well, you're turned all the way up.
No.
You got a booster?
Tell from that image that the tail light is fully intact.
You can tell it doesn't look like. It doesn't look like.
So I've got one that does.
It doesn't look like that. Do you agree it doesn't look like that?
Yeah.
Mm-hmm.
Yeah. Oh, yeah. This is a very deep case.
Oh, yes.
For a year now. He says he can prove that Karen Reed's taillight was completely intact after the alleged hit and run happened.
I love microdots. Love him.
Take a look at this video from the doorbell cam. It was taken at 5:03 a.m. And 5:03 a.m. is hours after Reed and O'Keefe parted ways. And you can see right there in the circle that Reed's taillight is right where it's supposed to be on her Lexus SUV. I want to welcome to the program Sean McDonough. Sean, that video is sort of jaw-dropping.
Yep.
It's kind of like the Perry Mason moment, and I wonder if the prosecutors have it, and if they do, how do they explain it?
Actually, first of all, I'm so happy to be here, and thank you for covering this. I'm so happy you led with the first picture. The first picture is what the prosecution wants the jurors to believe. Look, that taillight looked like at 12:32 a.m. after John was allegedly hit by Karen Reed. In this video, which is 4.5 hours after Karen allegedly hit John, that light right there has absolutely no wires, no LEDs. All the red is completely gone, which means no red would be reflective, right? There would be nothing. There would be nothing illuminated.
It is broken.
At 5:03 to 5:08, you see her back in. She cracks the backup light onto John O'Keefe's, Officer John.
Yeah, it is. It is broken. She even gets. Dan, you're so low, we can't hear you, man. Or I can't hear you.
I can hear a thing.
Absolute rubbish there. He's saying that, there's no lights, there's no wires. That's not true.
Let me see if we can zoom in. I don't know if we can or not. No, it's not zooming in. Yeah.
I've got a closer one. Do you want me to?
Yeah, great.
It's from the same chick that just did the last one. She did a tail-light thing.
Cracked, not smashed. You can clearly see. You can see the red. It's there. It's there.
It's from the same video.
Is not equivalent to all of this missing. And I want to shout out my friend Joe Flipperhead, who always has a very special way with his words. He's eloquent, he's thorough, and goddammit, is it funny as hell and sarcastic, all wrapped up in a cute little package for us.
Plant something that's already gone. The reason why you see white.
Not the same tail light? Okay. Let's see if I want somebody to zoom in on it.
The white bulb still
like start here, like Google Earth, and go.
Something that's already gone.
Let's see if we can find somebody that'll do that.
The reason why you see white, it is a red
tail light
cover, and when the red is
Let's see if
or gone,
somebody will do
as
it.
It is in this case, the white bulb still shines, and that's why it shines white.
I can understand why you wouldn't think that, because
See the two
snow
differences? That's her coming out of Meadow Avenue at 507.
You can't plant something that's already gone.
Let's see, zooming in on Karen Reed's.
It's a red tail light cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white.
That is not that.
Red tail light cover, and when the red is missing or gone, as it is in this case.
Let's go to TikTok.
The white bulb still shines.
I think we'll probably get better view on TikTok. Let's see. All right. Zooming in on Karen Reed's tail light. Because it does. Oh, man, you're going to make me do the objects thing. Hang on a minute. They don't believe I am who I say I am. They are the same shape. You're a liar. Give me just a minute. I'm logged in. Why are you making me do this?
Is that any better?
Yes, it is a little bit better.
You're clearer, but you're not very loud.
Yeah, you're not very loud at all. I had to turn my volume up to hear you.
Okay. Well, maybe I should do that because I turned you down before.
Okay.
Go again.
All right, zoom.
I'm here.
No, that didn't help.
On Karen tail light. All right, let's see. Okay, if I learn how to spell tail light, that might help. Okay, okay, here's one that says we zoom in on Karen Reed's tail light. All right, let's see. All right, can I bring this in real quick?
Yeah. Okay. I'm still trying to
This is from TikTok, and if it's on TikTok, it has to be true. All right. Can I make this bigger? No. Okay, this is kind of small, but for you guys, here we go. So this is actual video of her bumping into John's car.
The next 3 seconds.
Didn't they say there was another video that's just been
zoomed
found?
in on the moment they say Karen Reed broke her tail light? Okay, they zoom in on it. Okay.
Yeah.
Just pick on Reddit also.
Sergeant, were you able to see that video? I know it's not the clearest thing in the world. Were you able to see that video okay?
Yes, I
What
did.
did you notice about the rear wheel of the Traverse?
Based on the motion in the shot with the snow falling, it appears that there is movement, but the video speaks for itself.
What would you assess based on the movement of the rear wheel of the traverse.
I didn't see him zoom in on it.
Two vehicles came in contact with one, whether or not the
Did they zoom in on it? I didn't see him do that.
Yes.
Yeah, it was in that little window.
Oh, it was? Okay. I
Based on
want
the
to see it. Oh, right there. Okay. Do they show her back, like drive out and then show the tail
No,
light?
They
Okay, I
just
want to
show the
see.
wheel.
Okay, I want to see her
Video, I know it's
Karen
not the clearest
Reed
thing in the world. Were you able to see that video
tail
okay?
light.
Yes, I
What did
did.
you notice about the rear wheel
After.
of the Traverse?
Based on the motion and the
I want to see her pull out. That's what I want to see.
So he said.
Nice, nice.
Mm-hmm.
Okay. Oh, here's a picture of her car being towed. That you can't get more.
So I just walked
More than
I
that.
want have a look at the depth
by
of the snow.
LX 570 with a broken taillight. So the one that I saw was definitely a couple of years older than Karen Reed's. The one on the left is the one that I saw. And
If it's
you
not
can
Karen
see the
Reed's, I'm not
taillight is
interested.
pretty
It's
much
not Karen Reed's.
Yeah, I'm not interested if it's not Karen Reed's.
In that video that they were showing where they zoomed in, though, there's a huge problem in that from the defense's point of view. Because of the shape of the arse end of her Lexus, it wouldn't be the tail light that made contact with his car.
Well, there was no other damage anywhere else. It was isolated to the tail light. There was nothing else. There was no bumper disproportionate. There was no.
At
nothing.
those speeds, there probably wouldn't even be any damage.
What?
At those speeds, she was maybe doing 2 to 3 miles an hour. If she'd clipped his car, there wouldn't be any damage.
At the first time, no, but like
Yeah, she barely touched it. She said it cracked, but
that
it
would be
wouldn't
enough
broke
to
out
weaken
like that.
the actual structural component itself, so that it wasn't as stable as an intact one. But
Cracked, not.
Oh, I'm
smashed.
sorry.
You can-
oh, that
I'm sorry. You want me to add it back?
no, we've seen it.
Oh, okay.
I'm downloading or uploading the testimony of Daniel Wolf and how he explains what the damage was to the tail light and the bumper and the car and how they got to their conclusions.
Can we finish this with
yes,
Sean
yes.
McDonough? It's got like 2 minutes.
I'm not still uploading.
See those tire tracks? She goes in at an angle, which means she definitely made contact with the.
Well, you can
that
see the
side
car
light
move a
that comes
little.
out 5 inches. We documented this, and see right there, that tire on John's car moves forward. It didn't go backwards. So the angle directs the motion of the vehicle when it got struck.
Yeah.
So as that video continues on, if you keep going with that video,
All right, zoom in on it.
it's completely intact. And this is how it all came about. The lead detective, Michael Proctor for the Mass State Police, this is how I found it. In his affidavit, he said the taillight, the right rear taillight, right side, was shattered and a large piece missing. And I said, wait a minute. The two witnesses told him that there was a crack. And we analyzed this back and forth, and we let the video play all the way through. I went to Lexus dealerships. They told me not only do they have, it's a polycarbonate plastic, one of the hardest plastics you can have. The law of physics, there you go, right there. See all that red? In the final picture where the prosecution is saying this is how it ends up, it's no way. So polycarbonate plastic, very hard. 6,500 pounds going into a 220-pound male human will topple him over. It will not crack up the taillight in 37 plus pieces. Absolutely impossible. Mistake number one, they did not know this video existed when they did this crime scene later in the night. This video came about 2 days later. So when they made the
again, just listen, I've got only 30 seconds left, but I've got to ask you, you've been in this business a long time. How are the prosecutors going to explain this away? Because I guarantee you what you have, defense attorneys will use.
Oh, they have it all. They have that and more. I don't know how they intend to convince a jury of 12 that car hit John O'Keefe. There is no way.
Okay, do you
Wow.
want to
Okay, so
hang on a
listen.
sec? Do you want absolute proof that this guy's a jackass and talking out of his arse?
Well, I know Sean McDonough. He's not. He's actually a pretty nice person.
No, he's a liar. Pull up the video I've put backstage.
Can we finish this? It has 30 seconds. Oh,
I zoomed in.
There's the zoom in.
On that one. There you go. That's what proves he's a liar. Look how much further out the bumper sticks than the tail light.
So
there is no way she can do what he's trying to claim without there being damage to the bumper. It would be the bumper that made contact first. You'd have to compress the bumper in order to hit the tail light.
How far out was the traverse?
They talked they talked about that. His bumper's really low, so it still could have hit the tail light.
It's not that. It's how far the bumpers on the Lexus stick out that's the issue, not the bumpers on his.
No, well, the angle that she's on. Where's your video backstage? Which one is?
Is that what you're talking about, Dan?
No. If you look there, you can see it. But if you pull the one I've got backstage of a white Lexus, it's the same model but white.
It's just popped up. Hang on.
See how far that sticks out?
Hers doesn't stick out that far.
Much further.
On the angle. I want to watch that video again and see what angle she's hitting it at.
If you look, it comes right round and covers on the rear quarter. It still sticks out further.
Yeah.
All right. Well, just looking at that picture then, okay? How the fuck did that tail light hit the back of John's head? If that bumper sticks out that far and he's bent forward, how?
Yeah, that looks like a different model. It does.
Hers was the 2017.
I think hers was a 2016. Let me see.
I don't know, but
let me see what model Lexus.
Because there was no damage to the quarter panels, there was no damage to the tailgate, the lift gate, nothing.
Model the Lexus was Karen Reed driving. She was driving a Lexus 570.
Yep, which is what that is, the LX 570, same as hers.
Yep.
And I could have sworn hers was a 2017.
According to NBC News Boston, it was a 2016.
Okay.
But that doesn't mean they're right.
Look, there probably wasn't a great deal of difference, but
according to everyone on X, it was a 2017.
There's no difference to the arse end of a 2016.
Probably not. Yeah, you're probably right about that. And according to the Reddit thread, Karen is right about everything. It just popped up. I don't know. It's a 2017. Which Karen is not right about everything. She needs to keep her mouth shut. But yeah, it must be a 2017.
All right. I'm downloading this now.
It would take a hammer and a chisel to break that tail light, is what they're saying.
Did you not see
there you
those
go.
videos?
That's the 2016.
Okay.
Well, it doesn't jut out as far.
It doesn't.
Look at that.
But didn't she say she broke her? There would be injuries to his legs. I agree. Broken bones.
Yep. And she's cracked the far outer edge, like right on the is it the D panel there? The D. What's that?
What, the rear quarter?
No, the internal structure. You've got your C, A, B, C.
Oh, you mean your pillars?
Yeah, the D pillar. She cracked it on that edge of that D pillar, like on the angle.
Did she not say leaving the waterfall bar that she thought that she had cracked her tail light? before she even bumped into John's car?
I've never heard that.
Okay, I may be wrong about that.
Never heard that at all.
But that protrusion underneath the taillight goes right round the corner. It wraps around.
I might be thinking that she told her dad.
Out the back, it goes down the side as well.
Does it stay out the same distance, or
it tapers in, but it tapers in after the tail light.
So if she was on like a 90-degree angle directly with the traverse,
it would still hit the protrusion first.
What about if the traverse's bumper was like higher? And
we don't know that there was no damage to the lumbar. They just never focused. Yeah, they've just never focused on it. It's just always been about the tail light because there were pieces of tail light found.
But this has always been part of the problem with the defense. They start off saying there's no damage to the tail light. Then they say there's damage because she reversed into his car. Then it's a difference. This is the problem with the defense strategy. They're basically using a shotgun, firing it at the wall, and whatever sticks.
I can't argue with you. I really wish I could, but I can't argue with you about that one. They do go all over the place. They're not just sticking with it's actually this person. They are kind of all over the place. It's just, that's kind of the problem. I think everybody's hands, right. I think everybody's hands are a little dirty.
Yeah.
Well, the problem is that the defense are trying to win this case in the media, not in the courtroom.
So is Brennan. He did the dirty dog act of dropping that carrot with the date of the invoice and let it hang for a week just to fuck up their credibility.
But the defense's problem is the prosecution can win doing that. The defense can't because they have picked the hardest possible defense to have.
Yeah, but he had no broken bones and no bruises.
Turned the circle on themselves, though. They're not just saying she didn't do it. They're saying these people did it. Yeah. Now they have to prove that those people did it.
I have a video that I did during the last trial.
Hey, Chuck. Good morning.
That states exactly those three people and what I reckon happened. Like, I named those three.
Yeah, that's fine. But her team now has to prove they did it. Because that's the defense she's working on, they have to now prove it.
Yeah.
And that's going to be difficult.
They've known it all along. They just weren't able to do it with all the restrictions with the federal stuff. But I've got Daniel Wolf's here. Just a quick explanation of what they discovered, basically.
So from those photographs, I was able to identify there was fragments of transparent, red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a
You mean investigate properly?
whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all of the other evidence.
Or when it got there.
Correct.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yes, I think that's a fair characterization.
And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay.
No.
During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper, more so on the wraparound section as it kind of curves around to the right side of the vehicle. There appeared to be some superficial scratches as well in that.
Does the skull cause scratches?
That area.
Was there any other damage or deformation that you were able to glean from
exactly?
Your
Fat girls need love too.
Absolutely.
Damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there is some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Correct.
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely, yes.
Hey, Brian.
Any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
I do have another one, but I haven't had a chance to upload it yet, so we'll play part 2 tomorrow. And it goes into how they tested and what they tested to reconstruct that taillight the way that it ended up at the end.
Yeah.
And you talk because I just chucked licorice in my mouth.
You're fine. See, fat girls need love too. That's kind of the point. And as fast as they say she was going, him not having any broken bones and no bruising from the neck down is just odd.
That bumper would have taken his knee out.
Yeah. Or if he was bending over, his rib cage would have been crushed. Something, but it's not adding up. That he
How did you go down with the speed and the distance in reverse?
Still working on it.
Okay. Tomorrow's a day, Brian. Woohoo! Have you done your manscaping?
What in the world?
He's getting married tomorrow. You got to manscape.
Sure. I know, Brian. Dumb, 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 and I'm spelling that D-U-M-B. No, I'm just kidding. No, I'm happy for you. Yay.
And I was going through the.
Oh, don't say that.
Oh, boy.
No, make it special.
He doesn't mean that.
My nephew called me last night and told me he was getting married. Speaking of marriages.
You're very welcome.
Getting married at Myrtle Beach out on the sand. Right. Steve Bud, that's exactly the point. No bruises is weird. If he was punched, he would have bruises. Right.
Right, not fooling anyone.
And they said that she hit him going backwards at, what was it, 14 miles an hour?
24.
24 miles an hour. That's right. Yeah. 24 miles an hour backwards. In reverse. I'm sorry.
No DNA on the car. No definitive crash data.
Or there was DNA on the car.
There was touch DNA on the
there
car.
Was there was.
Hey, Jester.
There was a hair, a ninja hair that, if you look at the video when they retrieved the car from her parents' place and put it onto the tow truck, that car is like axle deep or more in snow. But that hair stayed, and that piece of glass stayed on the bumper.
Right, exactly right.
And there was no tire marks or drag marks or vehicle debris at the scene at the time.
Right.
Well, they did find parts of the lens
after it had been to the Sally Port
and drugged through
at the scene.
Oh, yeah, at the scene after the scene had already been cleared.
Well, which is sort of cleared.
That's
they didn't
weird.
Exactly do a good job on it.
Well, we can agree on that.
So initially, apparently, the defense pointed out that
right.
That they're hinting that John may have been attacked inside the house. That's where they started in the start of trial 1. And it's now moved to third-party culprit.
Right.
But I still don't believe that he was beaten up at all. Brian might be able to help me explain the Contrecoup. Actually, I've got some pictures. I spent so much time last trial putting together these presentations on showing examples of other head injuries that cause the same thing, other dog bites that cause the same thing. I should bring them up, find them somewhere. There is not enough hours in my day to do. I've still got 6 half-finished things. Honestly, I sat here from 2:00 this afternoon and didn't move, like just idiot, until 10:00 when Dan goes, "You want to chat?" I'm backstage and I'm like, "Fuck, it's 10:00." Yes, yeah. The actual, I did even part of that presentation too was the actual force that it would take to crack a human skull compared to the polycarbonate material that the tail light was made of. And the human skull is stronger. Believe it or not, it is stronger.
So this is on a Free Karen Reed site on Facebook. This is for those still denying that his attack was a dog.
They've got some more of the underarm ones. Have they?
That is John O'Keefe. This is someone who was attacked by a dog.
Oh, I have the biggest compilation.
Would you look at that and how similar that is?
Yeah. All right, I'm going to find it. Fuck his.
That is someone who was attacked by a dog, similar to Chloe. That is scary similar. Look at the scratches.
I don't know where I put everything.
Right, Bri.
Dog bite result summary? Maybe that's that. What's that? Whoa.
Now, they had cleaned him up at this point, which I think they should have took pictures before they cleaned him up, but that's me. But anyway. Well, I just showed my whole name, so there we go. There's that. Y'all want my address too? Everybody else on YouTube has it.
What did you do?
I just showed my whole name. I forgot to stop sharing the screen before I closed it. It's all right. Everybody on YouTube has it anyway.
Give me a second. There were so many things that were happening today. Like, I found the people that do the behaviour specialist, the behaviour panel.
Mm-hmm.
They had done an analysis of Jennifer McCabe. Oh, this is it. This is it. Shit-ot. Where did I find it now? So it was called blunt force trauma. Okay, cool. I can bring it up. Video file. No. 1.0, you dickhead.
You know what I'm going to stop doing? Looking at my memories on Facebook. That's what I'm going to stop doing.
I don't get on Facebook because
I don't. I don't. I use it to do stuff like that. But I clicked on it just now for some reason, and it showed me a bad memory.
Yeah. There it is. Got it. Okay.
True, bud.
Now, graphic content warning. Okay, just beware.
Not the world's best secret, was it?
All right. So that is his head injury from the back, and that is it from the front, as we saw the other day when I showed you that. So that was in ED when they'd ceased trying to resuscitate. So that trauma.
If we're just being honest, he was DOA.
So that was my theory at the time, that he'd hit one of those, see the blue things that I've circled?
Is that the basement?
Yes.
Oh wow! I've never seen a picture of the basement.
That's his actual basement, and they have those the doors that you go up the stairs and you can go out to the backyard. What are they called?
Barn doors.
Yeah, so you've got access to the backyard from the basement. That lifts out like old style.
Okay.
So I reckon he's hit one of those. They've been pushed back.
Very possible.
And that's what Mazza Media thinks. He came up with that theory the other day.
Oh yeah, you're probably right. Bulkheads. Yeah. Dixie.
So that was just me. It's playing. Sorry, that's explaining the hemorrhages that he had in his head. Come on, keep going. Next. All right. This is his the medical examiner's assessment. Okay. So
I gotta use eye drops. Give me a second.
That there was only they call it ecchymosis, which is the swelling behind the eyelids, and the blunt force trauma, 3 centimeter laceration to the back of his head.
That would have been perfect, really.
To hit the bottom half of that, it didn't fit. So there was nothing. He's got a Foley catheter in. That's catheter. He had a femoral catheter in, which, it's an arterial line to keep to make sure that you've got it. That's the most accurate measurement of your blood pressure and stuff that you can get. He had a couple of abrasions on his arm there that they've said, but the rest, there was no fractures. He had a little bit of bruising to the back of his hands, ID bracelet, ECG stickers, defib pads. That's it. That's from the medical examiner. That was the extent of his injuries. And see, that sort of explains how the blood gets out of the skull. So it's opened, the opening of where your eye socket is, it pushes forward, and then it builds that blood above the eye, in the eyelid. That's what a contricu looks like. There you go. There's another example of the same injury that he had. Okay. And there's another one. So she had the same thing, hit the back of the head, contricu injury. See the difference? I'm not sure if I had the
Is it, Dan? I just seen your message. 25.
this is the back of his hands.
Wow. So he could have.
See that? That you can even see where the IV they tried to get it in.
Yeah, but he was too cold, I bet, or dehydrated from drinking.
Yeah,
it could have been any of that.
Yeah. Yep. I did have another one on the dog bites. I'll find it for tomorrow.
Were you the one that floated this idea, or what? I've heard it from somebody.
What?
That he could have been hit in the back of the head with the barbell.
Wasn't me that floated it? No.
It must have been Miss Shorty. I heard that from somebody.
Barbell wouldn't do it.
I did hear that from somebody. Fat girls need love too. It's a possibility.
It's a massive head injury. Like it's a massive blunt force trauma to cause that.
Barbells are heavy.
Yeah. Barbell's the wrong shape.
But yeah, they're rounded, and that's why I can't see how that tail light caused that injury.
Hey, conservative connects. I'm going to call you conservative.
25 miles per hour impact is equivalent to falling 20 feet.
Wait, everybody stop. Magic's here. Hey, Magic!
Don't you know it's magic? I love that song. Who sings that?
I don't know. We do.
You should have a little sketch saying, "Don't you know it's magic?"
Yeah, I'm not on my StreamYard, but I downloaded a little thing just for Magic when he comes in now.
Hang on, I might have something that
good morning, Magic.
We might be able to use. Hang on.
Make sure you come to my stream, Magic.
Where is it?
Do you believe in magic?
No, this one.
Shifty. Hello, Shifty. I know you're.
Yay!
Hello, stalker lady.
Who's stalker lady?
Shifty.
Shifty.
Right here, Shifty.
Hello and welcome.
She has the best little accent. Her voice is so pretty. It is.
She stalks the hell out of me.
Really?
Yep.
No, not really.
She does. She admits it.
So, what's your opinions on the holes in the defense's case, Mr. Dan?
There are so many holes in it, you could drive a bloody bus through it.
You could use it as a sieve.
Yeah, it's.
Do tell.
Well, they've picked the hardest defense instead of focusing on problems with the prosecution. They've switched all the emphasis onto themselves to prove facts, which they didn't have to do.
Is there a minimum criteria they have to meet to do?
Yeah, the same as the prosecutions. They have to prove to the jury beyond reasonable doubt that these people they're naming did the crime.
Right. Is there criteria that would
have to meet
to call that defense? Do they have to meet? Like they can't just go, they did it.
Shift.
Like, do they have to? Is there a criteria that they have to meet to actually make that defense motion? Is my question.
No. So not to make the motion. They can decide to go with that defense. That's entirely
up to them. They can pluck that out of the air without having to meet any criteria at all.
Yep.
Okay. So it basically means it wasn't me, it was someone else.
Yeah. But they're specifically naming who it was, so they have to prove that. In order for their defense to be successful, they have to prove that. It's not just they have to show reasonable doubt that she didn't do it. They have to prove that the others did do it.
Yeah.
That's why people don't like that defense, because it's so difficult.
Honestly, you're the first person I've heard say that you didn't like the defense. You didn't like the defense.
You've got the Karen Reed fans are all just jumping up and down and arguing stuff that most of which would not be admissible in a court. And they're basing a lot of their stuff on crap that, if you actually look at it, comes from Turtle Boy.
You have a lot of people that think she's innocent that don't like Turtle Boy, honestly.
Yeah, but a lot of the information is second, third hand, fourth hand removed from Turtle Boy. If you go back and trace it, it comes from him, which makes that information suspect, to say the least.
That
the defense would have been far better off just raising reasonable doubt that she didn't do it. They've made life 10 times harder for themselves for no gain.
How?
Because of going for this third-party defense. It's the hardest form.
Nobody heard that? Sorry.
Oh boy, there she goes.
I was playing Don't You Know It's Magic. Well, what other things, like what other defense could...
She could have run just a standard defense. She could have run just a standard defense. She didn't do it. They didn't have to go the extra step in saying, not only didn't she do it, but these people did it.
Brian Higgins did it, I think. But
he's too weedy. He's too weedy. He'd get someone else to do it.
Remember, what
ATF agent goes, one, out drinking, two, threatens a cop and tells him to meet him at this house so he can whoop his tail because he wants his girlfriend, then leaves, goes to a place. Yeah, that video is coming out in trial. And then 3, goes to the police department drunk and moves all the cars around in the parking lot.
All right. Well, that's in my book. Count for the very first dipshit nomination for the Dipshit Award. Okay?
I mean, and isn't he the one that left all his stuff in Proctor's car? He left his badge and gun.
No, you're talking about the Turtle Boy issue with when he was arrested. He was out drinking with...
Somebody left their badge and gun in another cop's car. It was Higgins.
No, it was Proctor and someone else.
I'm pretty sure it's Proctor and Higgins. Let me look it up.
I remember they left it in a car because Turtle Boy... I remember hearing it from Turtle Boy, but... who the hell was it? Oh yeah, we were going to do bingo, weren't we?
Oh, I forgot about that. I'm sorry. I didn't update the thing.
Magic.
It was Bukkake. It was Bukkake. It was Bukkake.
Really?
Yep.
Magic, you have to forgive Miss Mandy. You know, at her age, she forgets things.
Yeah, Dan wants me to smack him in the face.
That's all right. She'll forget about it in 5 minutes, so don't worry about it.
Probably will.
I've got a lot of excuses then because I'm the oldest.
Look, we have a winner! Congratulations, Magic. Magic can't do anything wrong. Yeah, count on that.
So, I don't even know how to play these bingo card things. Like,
they're so much fun.
Do you have to put what's in the tiles in the squares?
Yeah, it just has you put them in a line, and then it mixes them up, and every bingo card's different.
And how do the people in chat get their own card?
You just click on the link. You pin the link up at top, and you click on it, and it makes it random. Gives you 30 random cards. It's fun.
So you've got to set up the thing before you put the link in, like what's in those boxes, yeah?
Yeah. And I have a Karen bingo, but it's from the last trial. It needs to be updated.
All right. Well, I'll think of. Is it things that they say or do, or
both.
Okay, it could be anything.
Yeah.
No, Magic, you won a visit
And
to a
when-
proctologist.
Did you win an e-bike? No, but if I ever get an e-bike, I'm giving it to Magic because he's always asking for an e-bike.
What the hell is an e-bike? Do I want to know?
Like an electric bike that you charge and you just.
I've got a scooter, electric scooter.
That's what he's talking about.
It's fun. It's awesome.
Is it fun? Cool.
Yep. Yep.
And you just when they do that thing, like say Lally would say, "What if any?" You would put "What if any" on the block, and they just click it. And when they get like 4 in a row, or then they get bingo. I do it once a month, and I give away Amazon gift cards.
Sweet. I know now what it is, but you call it something different. That's all. We call it like an electric scooter over here. But then
same thing.
My scooter's got 4 wheels, not 2. The bike's got 2, hasn't it?
Yeah.
Yeah.
Yeah. So everyone over 50 should have. Oh yeah.
I'm not over 50.
I'm over 50.
I'm not.
And I didn't get it because I wanted one. Trust me. Now, for those that are new here, generally for every trial that we go through, I keep a tally of people who you in chat nominate as a dipshit for the trial, and whoever has the most points at the end of the trial gets the honorary dipshit award. So
hang on, no, Teresa's wrong. You did know what a sausage biscuit is. Just you call them something different in Australia. They're sausage sarnies. You guys are civilized.
I don't even know what a sausage sarnie is. I honestly didn't know what a sausage biscuit was, but it looks delicious. And when
the fan's on, do we want to go over?
If you like, when Bri comes over to Australia and stays at my house after the wedding, he can make
is that
you
when
one.
you're going to have your threesome?
Oh my
He's
gosh.
getting married. And
Hence why a threesome.
Hey, let's behave. All right, here we go.
You're implying that that's my first.
Oh my gosh.
Or third or fourth.
I'm going to pull in.
Is 3 the limit?
Mickey knows what I'm talking about.
Why
She
would- why would
understands sausage sarnie.
Why would you limit it to 3?
Oh my gosh, y'all are horrible. Okay,
Well, you are getting a bit old these days. Yeah, we figured 3 would be enough.
We're back to the OnlyFan.
Dan, if you only knew.
I've heard the rumors.
15 years ago.
Blah 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 da 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 da.
Yep.
The OnlyFan has a following on X.
Oh, so is this a motions hearing?
It is a motions hearing, yeah.
And what time is it supposed to start?
In 10 minutes.
So we're going to sit and watch the fan for 10 minutes?
Sure.
Oh, for shiz McGears, really?
Yay!
If said OnlyFans, yeah.
Surely there's some other shit we can watch.
Sure.
Paint dry? I'm voting for paint dry.
No. Keep that there while I'm looking.
Oh no, I accidentally logged out of my YouTube. I hate it when I do that.
Haha.
Great.
Told you she was getting age.
I am, apparently, because you know how it makes you verify 20 million things to log in.
So, what's everyone up to for Easter? Anyone going away? No?
Nope.
Anybody?
Why would I be doing anything for Easter?
Because that's what most people over here do. That's why I avoid it like the plague.
It's just a long weekend. What's wrong with getting drunk and having good food?
It's an every day for me. Every day is a long weekend.
So this is a 1-minute clip. Can I show a 1-minute clip?
Absolutely. Knock yourself out.
It's called "This Is How Stupid People Are." I have no idea what it's about.
Serve their term. Come on, please. This is so easy.
Oh, I've seen this shit. That's funny.
I've seen this guy. He just says yes to all their answers, no matter how dumb it is.
That's crazy. Yeah, take a guess. What do you think?
Around how long?
Like time?
Yeah.
An hour?
An hour?
Like some of them ask, like, what country?
Years.
Oh, I said time and you said yeah.
Yeah, like how that.
7.
7? So do you remember what I was talking about earlier about people voting?
Do you know what's?
Some of them say, like, where is the Panama Canal located?
Yeah, I know. I've seen that, and they're like Egypt.
Where's the Great Wall? What country's the Great Wall of China in? Yeah.
Grilling out for each other. That sounds like fun. What time should I be there?
What's it? Is that a Barbie? Is that a Barbie? Grilling
Yep.
out?
Throw another grill on the Barbie.
Yeah.
State Utah's in?
Shrimp.
Utah?
Yeah.
What state is Utah in?
What's happened?
No.
What state does it sound like it would be in if you had to guess?
Brazil?
Hawaii?
How many states make up the United States? Guess a number.
2?
5.
52?
5?
How many seasons are there?
How many seasons?
May, June, July, August, September, 8? No.
I'm sorry, what'd you say?
I said 8.
Do you know who fought in the Civil War?
You know who fought in the Civil War?
Civil War.
Ooh, tough one.
The North or the South?
Real hard.
Like from the president?
No, like who against who?
The North and the South.
The Nazis.
What?
Versus Germany. No.
She gonna vote, boys?
You
Well,
like that?
this is a problem. It's a big problem.
How long does each president serve their term?
Okay.
Is there another one?
No, I can find more, but that was funny. That was really funny. He said she's going to vote. I think he is so funny.
Well,
hey, Methodist Dave, how you doing? Speaking of popping off on TikTok, Methodist Dave is bringing in them numbers.
Methodist Dave, what do you mean bringing in numbers? Well,
He's doing good. He's doing good on TikTok.
Oh, sweet.
Yeah.
I thought TikTok shut down.
No, they're just not allowing new people to sign up. It's in a holding pattern because us and China are arguing at the moment. We're not speaking. We're not speaking to one another.
Oh.
And if ever for any of you wanted to ask the question and need it answering of how Trump won the election, ta-da!
What do you mean? Because of TikTok?
No, because of those fucking idiots you just showed.
Oh, because they voted? Is that what you mean?
Yeah.
Oh, okay.
That's it. That's it. Oh, you can't see it. Damn it. Oh, I'll have to save it up in
Here, just show your layout.
Hang on. It's a background. I saved it as a background. So I'd have to take us off the screen.
Well, we'll live.
I can't. You can't see it. Hang on.
Is it Jesus?
Fast enough. Yeah.
Hey, they're back. They're not just showing the fan anymore.
Okay, let's go.
There you go.
Why don't I have volume? No volume.
I took you off stage to show the
Why
backdrop.
can't I hear anything? Can y'all hear anything?
Nope.
What in the world?
Have you muted the page, or has the
No.
court got no volume?
Court. Let's go
Might be
to
the
a
court
different.
feed.
Oh my goodness. We'll bring in Emily D. Baker if we have to. What in the world?
Is this live?
Yeah. I'm not bringing in Melanie Little.
No, but Lauren Crime isn't live at the moment on my thing.
Yeah, it is. But it's not just on crime; it's across the board.
So nobody has volume?
It doesn't appear that way.
Oh, okay. Okay, good. I was like, what in the world? Okay.
Yeah, sometimes it takes them ages to
Yeah,
get
they
that.
have to unmute. Come on, people.
Although you may want to use
I've got it on court TV. I've got sound.
Okay, let's go.
Yeah. All right.
Yeah.
Share screen. Yep, that's it. Share. Add stage. And play.
And of course, right after we filed that affidavit, the very next morning,
do you want me to back it up?
Commonwealth went ahead.
I would say yeah, because I want to know everything that's being said. Don't you guys think?
Yep.
Was your motion for a forensically sound copy? You wanted to be heard on that?
Yes, Your Honor.
Oh, she sounds
You did
so
not file
enthused.
on that.
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed?
Reconsideration for it.
A long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this
I'll be
court
back in a
reconsider
second.
the portion of the February 18th, 2025 order denying defendant's motion to compel the production of forensic of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
It seems the defense characterization that's forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file?
Because we've been okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case.
That's fair.
But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something.
Why can't the prosecution turn it over in discovery?
They did.
They did. They dropped and dragged it after they had orders.
Because they wanted the metadata.
And they had orders.
And the defense are stretching their definitions of forensic to try and be a little bit awkward.
But they had orders to not drop and drag it. Yeah, they had orders.
No, they didn't. No, the motion
requested.
was refused.
They requested it. Okay, they requested it. Okay.
The motion that they said for not drag and drop, was refused. And then they're bitching because after that motion was refused, the police did drag and drop it because that's what they were supposed to do and handed it over.
Okay.
But
the police did nothing wrong. The court said, no, you can't have what you asked for.
Well, she hasn't said that yet. She's going to rule on that.
This is, remember, this motion is against the other motion that already had been done.
Okay. Well,
why wouldn't you want them to have the metadata? Why?
Because of the way they wanted.
Yeah, he said it's attached to other cases.
Metadata was they wanted to image the entire archive that the police has of every case.
No.
And they can't.
They wanted the detective file, which is everything. That's every single case.
They didn't even know what the Canton Police Department had. 1 minute it was on someone else's hard drive. They just wanted the relevant material that had the metadata attached to it.
No, it's not that. No, Jodie, you're missing it. It's the way they wanted
and then discuss it out.
The way they wanted to get the metadata was to copy the entire drive. That's the problem.
Let's hit play and then discuss it out.
No, because they're moving on to the next motion, Amanda.
Don't call me Amanda, please. Only my mom calls me Amanda when I'm in trouble.
I just don't know how.
Behave yourself, Amanda.
I'm gonna kick your butt.
Right.
About how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between Commonwealth.
Right, but we have to make arrangements. So that was something that I asked you to figure out.
It's fair that they can't download the whole thing if it has other cases.
How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
That's fair.
I do need you to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense.
I don't think the defense or the Commonwealth should be with the jurors.
We do.
If they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
the date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to
So why don't I see Counsel Tybar about this anymore?
Yeah, I don't think the defense or the Commonwealth should be on the bus with the jurors. That seems inappropriate either way. What do y'all think?
There should be representation from both on the bus with them.
Or that. Yeah, either way. Either nothing or one of each.
Yeah. I'm trying to find this motion.
Okay.
Motion to
Yeah, either both or nothing.
There's so many notions. Do you know when it was filed? Was it in?
I don't.
It was for the last trial, the original motion.
No, they've filed a new one since then.
I have to go let my dog out. I'm sorry. I'll be right back.
The new one since then was trying to, because the prosecution have been releasing drips and drabs in discovery to them every, in bits and pieces. And they eventually, after the end of the first trial, they said that there is more stuff that they've found on a retired police officer's hard drive or something like that. And then it changed to the Canton Police Department's something else. Like every time they'd go to address it in court, Brennan had a different place where it was being held. And they only wanted what was relevant, but they wanted it with the metadata attached because of the issues they had with the Sallyport videos and everything else. That's why they wanted it intact and not dragged and dropped. But the prosecution refused to do that. They just wanted to.
The court refused permission for that.
Yes. Why, I don't know. But yeah, that was a request for forensic copy of. I've got it here somewhere, but you've got no idea how many documents.
Oh, it's a lot, but it's all to do with how they wanted to copy the data. And the way the defense was wanting to copy the data was a bad idea because their version involved copying the entire database, not just the specific.
That's from the first trial. That was the first trial, though. This is the second, and it was a different motion. It was like only last month. Completely different, because they didn't even know about it. What this guy had, this retired police officer, or some shit, had it on his hard drive.
But the defense has also completely ignored the fact that they've been invited several times to go down and look at the database to see what's on there with their expert.
But if it's I suppose.
To be honest, it's more of the same stuff that both sides have been doing, and they're playing like little children and forgetting that this is about someone's life.
No, you can't have it. Rah, rah. They're just making it difficult for everyone.
Yeah. I don't want it this way. I want it that way. It's all childish.
It's a waste of time and a load of crap.
Yeah.
Like the motion that Hank Brennan put forth about not getting all of the discovery on the federal investigation. Of course, they're not going to hand it over to you, you dickhead. They're investigating you. And he's trying to blame it on the defense. We're not producing it. And then he's like, well, the defense didn't tell me that they supplied their entire briefing to the FBI. Well, no. We have no idea what they've supplied. They've obviously got a relationship with the FBI. No, they're just following the requests that they would just provide this for the feds. He's a dipshit.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor. And then we can move on.
Did you hear he requested to have the manner of death not be told by the medical examiner? And then he opted not to call the medical examiner. How's that for selective information?
Doesn't matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant.
An erroneous remnant.
Okay, so why don't you just provide me with the new slide? So
Isn't
I
there
know
a
what it
trap for
is.
that?
Okay.
I will do that.
All right, thank
you, Your Honor.
Okay.
It sounds like something you trap and kill.
Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I did read it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
I am.
Oh, that was loud.
Oh, I'm sorry.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter,
That might be problematic.
Or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, etc. But otherwise, it's the same substance.
Is that your puppy?
So
Yeah,
provide me
he
with
wants
the
attention.
redacted one as well, and I'll take a look at it.
Right.
Okay.
That has. I will do that, Your Honor. I'll provide the court with that forthwith.
Forthwith.
The second is on the substance.
I like
Lieutenant
Alexei.
Wing,
He's professional.
extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines,
Wow.
not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites 2 specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this.
Uh-oh.
The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing in his qualifications exceed that of Dr. Crosby. And
it's not me.
My request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say, I am not going to get into
I reckon it's because
the basis for that. I just wanted to, because
just go ahead. Just move on.
Yeah.
I'll just back it up a bit because I think
and
do you
my
want me to pull
request,
up another
Your
feed, or
Honor, is
I think there's so many people trying to get at this feed that it's just.
I'm sure that's what it is. I'm at the exact point on Law and Crime. Do you want me to pull it up?
Yep.
Okay.
I'm still looking for this document anyway. I've got one half. I got the response, but hello, sweetheart. Sorry, I had my screen covered.
Okay, they drop the feed and then pull it back up. Let me get to it.
I'll take mine off.
So it's at the point where Alessi stops.
Is that you at the bottom?
No. I'm trying to get to the point where Alessi stops. Because it looks like it was their feed because they dropped the feed completely and then bring it up. Okay.
This is your feed though, isn't it?
Oh, sorry. No, it's fine. This is me.
Okay.
No, apparently that's not me.
What? It's not me. I can't control it.
Okay.
Now let me go to.
All right, let me present, share. That's me right there.
Again, Your Honor will make that judgment when the court believes that
It's
notwithstanding.
it's the court. It's going to happen on any feed, and then it's going to drop, and then they pull it back up.
All right, so take mine off and put yours up.
Okay, ready?
Is that the plan?
Yeah, go ahead. I'm ready to add it. All right.
Okay, I'll take mine completely off so I don't get confused.
Regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby's an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites.
What?
Even her feed is still dodgy.
Yeah, it was a court.
But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times. And that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly.
Right, actually.
It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between.
I'm sorry to pause it, but how are you going to prove it was that dog? Or do you show Chloe doing the mold? No, I bet you don't.
The molds and the spacing on Mr. O'Keefe's arm, it is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable or consistent with a dog.
Hang on. Back to fucking chocolate. Really? So to point out the natural structure of a dog's jaw is somehow not allowed. You cannot opine that they have canine teeth or they have molars or.
This is his polite way of arguing with the judge.
This is him being a dipshit.
Right. Opine should go on the bingo cards. I agree.
Yes.
I'll work on that.
Case in chief and rebuttal that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's just wrong.
It's an uphill battle.
One look
I'll
at
tell
you,
that.
and I know that you are an idiot.
Thank you, Your Honor. I can go through this quickly. the National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there being discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed?
Yes, Your Honor.
So you both
That
have
was an easy one.
motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
It's your job to make sure it gets done.
Okay. Who's arguing this for the defense, or who's telling me what's going
Your
on?
Honor, we're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends
Shocker.
to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right, I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you.
Such a suckhole.
So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process.
To make
and
it seem
my
like it's
office
something that
sent
it's not? Okay.
A slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44
Over-inclusive.
clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
Yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So, all right, so we'll just take a look at that.
That's like a person that takes a 10-second clip out of a 4-hour live stream and says, "Did you see what they said?"
Out of context and everything.
Yep. I hate it when people do that.
Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
But we could have somebody plain clothes from the state police, or we could find somebody.
That's
who's
not
able to
independent.
defense, but I think it would be best if we have an independent reader who's available throughout the trial.
What is he
He
asking
wants
for?
he wants an independent reader. He wants somebody that's not involved with the Commonwealth or the defense to read text messages so that there's not, quote, drama behind the reading. He said, we could have a plainclothes person from the state police do it. That's
Reading
not
what?
text
Reading
messages. And,
From what?
and from
Oh, isn't it like an exhibit?
I'm guessing like Proctor stuff is what I'm guessing. And other text messages from like Brian Higgins and whatnot.
So there's no emphasis on either side.
Right. But a plainclothes officer from the state is not an independent reader.
No.
But let's see what she does.
To play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Jackson's going to inform him of that, I'm guessing. Where did the volume go? The volume. They're talking to each other. Okay, I got it. Okay. I think putting emphasis on text is kind of part of the defense, though. Isn't it their job to put emphasis on things? Just like it's his job to put emphasis on things.
I don't know. If it's text messages they're reading out for as an exhibit. Then,
Your Honor, thank you for the
I don't know.
time to consult.
Normally the witness that does it, though.
I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively we can have somebody come in
who simply reads those
To
text
read
messages
Karen and
when
John's?
they're appropriate.
Okay, I don't see an issue with
I
that.
would disagree gently with Mr. Brennan.
Oh.
That's exactly what the proper protocol is. If Mr. Guarino is the one who found, if he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously.
Yeah, he was saying he didn't want him to do it.
Having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male or
They want a
and
narrator.
And that's exactly what we don't want.
Yes.
I think that's inappropriate.
Do you
It's
know
not
what?
gonna be Mr. O'Keefe, and it's not gonna
I
be Mr.
don't.
Reed.
I
The
don't
text
think we've
messages
seen.
speak for themselves.
Can you pause 1
The
sec?
jurors should be able to analyze the words that are on the page, the text messages
Can you
as
pause
they
it for
were
1
written
sec,
and
Mandy?
drafted,
Yeah,
not the inflections and the repartee between.
Yeah, I agree with you. Something seems amiss here.
Do you know what? My prediction is I don't think we've even scratched the surface of the depth of the dirty that Brennan will bring to this trial. That's my
Like, why have an independent? What? I agree with Jackson. Why not just let the jury decide? Because that's kind of their job.
How that whichever witness brings in the exhibit can read it. Like,
Now, if it's just somebody to read John and Karen's, I'm okay with that. But to read everything, no.
Who wants to read Proctor's statements? No one. He can read them himself.
Yeah. Now, there's no one to analyze John and Karen, so I don't love it, but I can kind of see that.
Yeah.
But to read everybody's, no.
He's trying to control everything. He's like, what is it called? Micromanaging.
Micromanaging, yeah.
Independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps
that's a good
not
point.
State trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done.
All right. I will consider it.
There'll be no inflection. That would be
so she's going to put it through anyway.
Of course you're going to say that, though.
All right. Defendant's motion for specific discovery, paper 638, Jimmy.
They're still asking for specific.
All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion with regard to 3 and 4. I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay. Where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Oh, number 5? Yes. With regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay. Thank you. All right. The ARCA witnesses. Motions regarding that. So,
oh boy,
where do you
How did you vote on
stand,
that?
Mr. Brennan, with what has been provided and what you might think has not been provided?
I thought she had 2. So let's see what's going on.
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions,
I'm sorry, really? I think they are aware of candor, truthfulness, and full
Give him
disclosure.
all of it. They can't give him all of it because they don't have it. It's part of the federal investigation into the Commonwealth.
But he wants to know what they know.
Yeah, I know.
That's what it's
And he's
all
blaming
about.
it on a discovery issue.
we want a full vetting
There it
of
is.
that history. On a prior date, the court
Can't have everything
know
else.
what got
perhaps
against
we
him.
could have a voir
Yeah.
dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses
No.
and the defense.
That's an excuse.
That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So
He wants the text messages between
their custody and control.
I'm sorry.
The defense
And then
and, defense and ARCA.
You don't get all that.
He thinks they've been colluding, and they've been their testimony was like
no, dude, you don't get all that.
But
I admit the timing of them hiring them looks bad, but it's just coincidental is all it is.
They didn't hire them.
They hired them after the federal thing was over.
The federal government, the feds had these witnesses report because they were investigating the investigation of the death of John O'Keefe.
Right.
And they wanted their own experts to do that. So they gave them just enough information. They hired like ARCA is an independent company.
Mm-hmm.
They found the best people they could find, told them the bare essentials of what they wanted, no other details. And that's how they worked out the accident reconstruction and how they established their report so that it would not be biased in any way. Then once that was done, that report was offered to both sides, the defense and the Commonwealth. Commonwealth refused.
Yeah.
Obviously.
And he's trying to fix that screw up, you think?
And the defense accepted, but they were witnesses hired by the Fed. So
didn't they hire them after the federal investigation was over though?
No. What happened was that they were still under retention by the federal government, and then towards the end of the trial they were released from that, and the defense called them as witnesses. And then just after the end of the trial, the defense got this invoice for $23,000, and they didn't know what it was, and they rang I think it was the Department of Justice or someone, asking what it was, and they said, well, yeah, it's for the ARCA witnesses.
And they're like, no.
Go ahead and pay it. So they did.
Oh, okay.
But they didn't go and search for them. They were handed on a platter. They were happy to have them up on the stand without even knowing what was in the report, without even seeing it.
Okay. All right. That makes sense then.
I asked the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it.
But they bore down both of them last trial.
Secondly, the defense has provided that they have retained the ARCA witnesses independently.
Yeah.
We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further
Spelled like
opinions,
ARCCA, I
any
believe.
further ideas, or any further reports. So the two things to simplify it that I'm looking for.
Let me look up exactly what it
is
means. I don't really
for the
know.
court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Just pause a sec. They only testified to what was within that report. They didn't go outside that scope. They don't need any more. Nothing's changed. Nothing has changed. They don't need to do any more discovery. They don't need to do any more testing. They just need to testify on their report. It'll be American.
What does ARCA stand for? Allegiance and Regional Collaboratives for Climate Adaptation, apparently.
Yeah, they're all
It's a part-
biomechanics and engineers.
Yeah, they're biomechanical engineers.
Yeah, yep. It's an independent company that the federal government hired to do their accident reconstruction.
They're forensic biomechanical engineers, to be exact.
They didn't even know Karen Reid or the trial or anything like that at the time of their report. Nothing. Knew nothing.
Here you go.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we...
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day.
That's fair.
If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding.
Yeah, you need to contact your experts though, and find out why, if anything new's coming. That's on you. Just trying to be fair.
Yeah, but what then
Well,
happens,
I get what he's saying though.
What then happens is Hank goes and says that they're I can't think of the word. They're like leading them by doing that. Every contact that they have. That's why he's asked for all the emails and text messages. He's saying they are trying to influence their testimony.
Right. Which
they're damned if they do, and they're damned if they don't.
Hiding anything where, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith.
It seems like it.
With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go
What
through
number
those
was that?
if the court wishes me to, but
Hold on one second.
I'm not sure.
Are there specifics that you say are still outstanding of the 13
I'll
and
look it
how
up.
many points there were? Because this is on what you filed. So
yeah,
this is not unusual. A party says we asked for all 13, another party says we gave them to you, and then the party says I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about.
They were just able to hire on them.
Yeah, because who's held it up? Who's held it up?
This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different.
Even she's giving you a dirty look.
We do not have all the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing.
She's deep breathing at him even.
Okay.
So my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated. And then
you got an issue.
So address number one, Mr. Jackson.
The number one issue that Mr. Brennan has.
Wait a minute, I have a tissue for him.
Yeah.
I have a tissue for his issue.
Anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages.
Wow.
Responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera. We could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission.
And who held that up?
They gave both sides permission on March 26th,
CC
2025.
right.
We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied.
I had a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the on the biological side.
There was a difference between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well. But
Is there anything that they're going to say they cannot provide because of the federal investigation?
not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Wow.
I've got the first.
Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that is on. That's
Can
on
they
the table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counsel Tabar, please?
Oh boy.
She knows this. She knows this.
Yeah, I'm thinking you're right.
And you can't.
This is wild.
It's an. Yeah, you can't produce something that you don't have or you've got no control over, or like he's asking for discovery for anything that they've tested within the last 3 days because that's how long they've had them for. Like, it's just so unreasonable.
I'm gonna zoom, as Emily D. Baker would say.
How long do you reckon this motion is going to go on for? Where's Dan?
I don't know. He's muted. I think he's down there.
I'm looking for this the list that they're asking for ARCA. Because it is just ridiculous.
Wow. Got sidebar for a hot minute.
Oh, you've got a little bit of room to move. You can fast forward with that.
Well, there it looks like they're heading back. Here we go.
All right. So, Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report.
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right. And then subsequent to that, information was provided by Mr. Yannetti. And you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice or the U.S. Attorney's Office was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when did you do?
Provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. Okay. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect, in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
It's probably a better guess, yeah.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
Oh, wow. They literally just got permission.
Yeah.
No.
No, here we go.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had.
I thought the last issue was the issue you've been concerned about.
They didn't testify outside of their report.
Oh, gosh. He's worried about every issue.
Yeah.
The fact that I anticipated this very thing would happen.
That's why.
When I began this case.
And ask yourselves, because there's several of you that are just getting to know this case, why is he so concerned about them? Why?
He's got $225,000 worth of incentive to date to have a conviction.
Yep, absolutely.
And they are his big. They can't attack their credibility because it's like exemplary. You can't attack anything else. This is his only way in, that he's trying to make an issue out of something that isn't even there.
Yeah, you're right.
He's a knob.
Case beginning of October, end of September, this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never.
Liar.
But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled.
The ARCA witnesses
You're entitled
provided
to
a
something.
report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provided a report does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information and reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV.
We tried.
We met our discovery deadlines, and they were hard.
They tried.
Why would you give up? Why would you give up the witnesses that the federal government have chosen to be the best representations to do so and are guaranteed to be proven non-biased?
Yeah.
Why would you hire anyone else? Hello? The job's done for them already.
Jeez.
If the state has got all this money.
Exactly. This guy
Welch's
here.
CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses. They have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury.
He said there was nothing new.
Science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign
there
them
was
to
nothing
review
new
information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to
do. Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st.
My dipshit nomination.
They've been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth
he set this stage up.
Disclosed.
And now he's playing it.
In February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dried. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can.
Howie's the popular one.
And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report.
I
There's
have
nothing more.
I was just about to say, the communications that they had with U.S. Attorney's
you
Office,
anything like
I don't
my
have any
stuff?
access to that. That's confidential. But I do know what they provided to them for their analysis. That is all
Like my
listed
hamster.
in the report. And both sides have had that from the day we received the reports. The federal disclosures. Both sides have had those. So nobody was in
Do you know him? Is he a cousin?
in the first trial, and certainly nobody's at a disadvantage in this trial.
I was asking Howie if he knew that hamster.
We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
He set this up from the start.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November. And then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
He said that. He said there was nothing new.
Mr. Alesi, who is much more facile with the facts of what's in Judd Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher.
He sure did.
The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you.
He's got to do everything in his power.
I think is the only thing left the motion to sequester Aidan Kearney from to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that? I thought that you were going to.
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that
And what do you want?
assertion.
What do you
That's
want
not
the
the state of the
ownership
law.
for?
We did provide notice to the
Exactly.
Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay.
Oh,
Are we
we're coming
allowed to
back
make an oral
tomorrow.
argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know what I need is, I wasn't expecting this here today. So what I need is the paper number. I think it's the Commonwealth's motion to exclude. But the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right. So we need to take a recess anyway, so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number on what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Oh,
2
boy.
seconds. I reckon I can find that.
Okay. Okay. If you can, I can probably find it.
Documents.
We might actually catch up. In fact, I think we're caught up.
3
Yeah.
days ago.
We are caught up. Wow, we're in real time. Look at us. Oh, professional and whatnot.
What was the motion for?
I don't remember what she said. It was 4 police officers' conduct to.
Oh yeah, yeah.
Okay, let's see what time they went. So they've only been gone 10 minutes. So we've got 5 minutes to go.
Yep.
Chicky monkey.
Documents. Come on. Hurry. Do 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 do
Do do do do do do do do do do do do do do. Okay. I'm going to let Jodie entertain you for a minute because I have to. Well, I have to do something. I'll be right back.
Who's that? Who? All right. What was that theme song off? What was the Oh, I'm looking under the wrong thing, Jodie. You're a dickhead. Dickhead. And I tell you, right now, I am actually on Discord, and my search is using the best, absolute best utility and resource for true crimers. It is a channel called As the Gavel Drops. They have listings of every single court case, the dates, everything is then linked to that name, every media coverage, every newspaper, every YouTube channel presentation, and all of the documents that go along with it. And it's in like chronological order. You just got to find where it is. They have everything. So if you're looking for something, go and join the channel. And they've got other stuff as well. They've got, you can have chats about different trials and all sorts of stuff. But they also Like every time I do a live stream, they actually promote my live stream for me. They put it out into the Discord webs, so to speak. And they do that with, let's have a read, shall I? How about I share the screen, because it might be easier if you see what I'm doing. Present, seeing as we're only watching a fan over there.
Sorry about that.
No, I'm just telling them about as the gavel drops, and I thought, well, they may as well watch what I'm
they're
doing.
great. Yeah, they're great.
They are amazing, and that's my background. It says I'm telling Dad.
Jesus, I'm just kidding.
It says I'm telling Dad. So at the left-hand side here is the menu. So this is the most important one here, because a lot of the documents and stuff that they provide for all the cases, and they don't charge you for it, but sometimes they're behind a paywall, and they actually have to pay for the documents that they provide to us. So it doesn't cost you anything to join them. It doesn't cost you anything to use any of their information, nothing. So they just ask, it's called buy a document. So you just make a donation basically towards their funds. Now, all of these people are true crime channels. Okay, so you've got Recovery Addict, ADK Brown, Community Advocate, Equal Med, Law and Lumber, 13th Juror.
I wonder what I need to do to get on there.
Second, the defense rests.
I wonder what I need to do to get a channel. Just make a donation.
Look at that. I don't know. I just popped up there one day, but it's Toxic Orchid that you need to speak to.
Yeah.
I'm under Uncivil and Runkle of the Bailey. There you go.
And both great channels. Let me talk to her real quick while we're waiting.
I actually don't know how. Mind you, I do every stream I have a banner up to promote them, so maybe that's why. But she found me. Then you've got general bits and pieces, upcoming cases, but then it tells you what's actually in session. So Laurie Vallow, and then that lets you choose which bit you want to go into. Karen Reid. All right, look, there's documents for Karen Reid.
I'm sorry, Shifty. I'm just now seeing your Discord message.
Sleuthy Goosey is awesome.
Right, Sleuthy Goosey.
Awesome. What's the latest one? Jump to present.
My dog wants attention so bad. Do y'all hear him?
Yeah. Motion
I'm sorry.
To add. Oh, that's the other juror, isn't it? Victoria so-and-so. Notice a visual aids Commonwealth notice to
Doug.
Let me see if I can widen that page.
Doug.
How do you open that up a bit more? Oh, I don't know. That work? Nope. I can't read the full name.
Okay.
Notice. Commonwealth Notice of Discovery. Canton Audit Assessment. Commonwealth Notice of...
Who is it that I need to talk to in there?
Toxic Orchid.
That's right. Duh. Yeah, of course that's who I need to talk to.
I can't read the full name of it. How do you open it up, Mandy?
Let me see what you're on exactly. Just click download. You don't have to download it.
Yeah, but it comes up untitled on my thing. I want to see the full title. That's all.
Oh, okay. Well, just click on the link, on the blue link.
I did, and it keeps coming up.
Okay, right click it.
Hang on, I've got to close all these tabs now.
You shouldn't have to. Right click it and then tell it how you want it to open. There you go.
I just want to see the full name.
Well, when you open it, you'll see the name. Okay, see how it opened up a bunch of stuff to the right? Slow down. Okay, give it a second and it'll open up stuff to the right. Okay, see the 3 dots? Go to the 3 dots. Okay. Now go to, it's
Surely
really
there's
small.
got to be something to open that, stretch it wider.
Yeah, you can't just open it? Or you don't want to do that?
Oh, shit, what have I done now?
Here, let me go to where you are.
It's my bedtime. I got to go to bed. I do. I'm absolutely dead. My brain stops working now. I clicked into my own and I can't even get out of it.
All right, let me see where you're at, girly girl. All right.
If you scroll down the left, it's in session, the third one across.
In session.
It's just the list. I need to open it up wider.
Gosh, there's so many files. Okay, let me see.
No idea yet. I just want to see what the latest one is.
Session.
See
I
how
don't see in session. I see chat about past trials by document. Need to verify.
Scroll down. Cell block fund, news.
News.
In session. It's got the green go lights.
Scroll past all the channels.
Yeah, all the chit chat.
Oh, okay. In session.
Yeah, in session, Callie.
I just don't see it. Allegedly, Crime Cafe, Public Buzz, Alternate Juror,
Yeah, keep going.
Okay. Daily Theme, Server Polls, Book Discussions, Grow Tree, Live Streams, Unsolved Murders.
News. Yep. Next one says in session, Callie. After Unsolved Murder Case of the Month.
Unsolved Murder Case of the Month, in session. Okay, so
yeah.
So the third one down. Third one down. Okay, Karen Reed.
Karen Reed, and it will move you across to the right to where you can choose.
See all.
No, you just want to. I was just searching for the document, so just click on the document thread.
Okay.
Now it brings up what I've got here.
Okay.
I want to be able to see how that's a rectangle.
Yeah.
I can't read the full name.
Okay. What are you looking for?
Well, whatever they're arguing now. This motion.
Oh, okay. It's for the 4 police officers for.
That's why I need the full name of it because I can't.
Police.
There's got to be some.
4.
Like.
Well, 4 is not in the title of the motion.
No, it'll be here, but I need to see the bloody thing.
Yeah, mine looks completely different than yours. I have the names on mine.
It has to be like a setting, like a.
Let me see.
Open in split view. What's that? Oh no. All right, maybe I can stretch it this way. No.
You see, mine doesn't open like that. Mine opens up completely. I don't know why yours opens like that.
I don't know.
Yeah, I can hover over it and it tells me the title.
Really?
Yeah.
I can't.
All right. Yeah.
It's normally easy.
Yeah.
It's the driver that it's
No, I don't think it's you. I think it's maybe your Discord, or it's not up to date, or maybe mine's not up to date. I don't know.
If any of the YouTube people that they're affiliated with post on Karen Read, they also go into here. So there's everything that you can find on Karen Read in this.
I'm trying to find that motion.
Commonwealth notice of statements of the defendant. Unopposed. No, I don't want that. Commonwealth notice of intention to introduce extrajudicial statements. Visual aids. Motion.
I think this might be it.
It's not coming up now. Petition of writ of.
Okay. Right. 4.
Writ of certiorari? What the hell is that?
Okay, they're coming back. Can I go back to the stream? Okay. Thank you, Jesus. All right, here we go. We never see the thing starting to rock.
We need someone behind the scenes to
hug Doug. I'm trying to get him to come to my lap. Come on, get him to my lap. Come on.
To help search
it. He wants out of the room. Let me let Doug out.
We need a fact checker and a searcher.
Go in there with Larry. Come on, let's go in here with Larry. Come on. Let's go in here with Larry. Come on.
Because it's this crap that takes all the time. A petition for writ of Pretoria.
Sorry, I thought they were coming back because the
no idea what that is.
Camera started rocking. Can you hear me? Oh, I came unplugged.
I can get out of that. All right.
Well, stream set up in 25 minutes. That might get delayed.
Who's Carl Mayasako?
Why?
He's a witness.
That might be one of the 4 new officers that they're wanting to introduce. That might be exact. Sorry, that went down wrong. Might be one of the. That might be exactly what we're looking for.
All right, hang on. I'll save it.
I'm still looking. Oh my gosh! For the people who watch the YSL trial, y'all will never guess who P. Diddy's new lawyer is.
Hank Brennan?
No. It's look, I said something and then I forgot his name. Let me go to
this is a DNA expert.
It's Brian Steele, who represented Young Thug. I can't believe it. I can't believe he took the case. I cannot believe he took that case. He took a case that is a sure loser.
I don't follow any of those.
I tell you what, though, if I had any case from a traffic ticket to unaliving, I would hire Brian Steele. Though he's the man.
There's a verified complaint here from Judge Canoni.
Against who?
I don't know.
I'm sure it's against the defense.
Let me save it and open it. Verified complaint. The Karen Read trial has drawn significant public attention. Plaintiffs are members of the public,
Wish to publicly. Oh, this will be about the buffer zone, I bet you. Constitutional guarantees of free speech and due process. Canoni has issued this order primarily to squash criticism directed at her, as this the only protest.
Okay.
Here we go.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
You're welcome.
Okay.
If the court will give us, another day or two to discuss with the Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right.
Well, that's going to be about
Morning,
8.
Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that.
I've got the jury question here.
I probably have it here too. I have one, Jim. Thanks. All right. I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth
All the
intend to call
witnesses are
him
being
your case in
sequestered?
chief?
It depends on the
Yeah,
development of the
that's
case.
been-
There are two issues that are
that's
important.
been
One is
under-
case in chief is whether or not there's any development of third
Been
party
asked
culprit.
to rule on it.
If there is,
Yeah.
Mr. Kearney becomes a more important witness, and we'll have to assess that.
He
as
wants
the case
to shut him up.
Yep.
The other is rebuttal. If
Uh-huh.
the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
That way he keeps him out of the courtroom.
All right,
and
now I'll
stops
hear you,
any
Mr.
bullshit
Bradle.
on-
All right, thank you very much.
And he doesn't get to be on
He
YouTube.
controls
Let's just be
what's
honest.
on social media.
Yeah, let's just be honest. He doesn't want him talking about the case and
Yep.
influencing opinions.
Yep.
He just wants to control every little aspect.
Yep.
Good night.
Much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Carney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor.
Yes. Yes, it is.
The government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you
I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Oh, if you have to, really? Surely.
Your Honor, you have
I'd
questions?
rather watch paper,
Yes.
right?
What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Of course he does.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Look at him smiling.
Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
Sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Oh no.
Everybody's
They're
gonna Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
I've got the jury questionnaire that was sent out.
You do. Let's see that. Okay, we're up to real time. So let me drop this back.
All right, I will present it. Share screen.
That's from The Odd Couple, isn't
it? I can't remember.
No, that's not from The Odd Couple. That's from he was Mary Tyler Moore. Where was that from? That's gonna drive me crazy. Anyway,
I don't know. How do I zoom in? All right, share screen. Oh, you got it. Cool. Yeah.
you hold control and you hit the plus sign to zoom in. And there's a plus down at the bottom right. Looks like
that didn't work.
Or hold control and roll your mouse and see if that works.
Hang on. This is a different version I've not seen. Oh, there it is. There.
Yeah. There we go. Oh yeah, much better.
Oopsie. Oh.
Screw it.
My fingers don't work. Don't get arthritis ever.
Oh, I have it. I don't have it in my fingers though. Just
look
back and legs.
Look at that.
Oh,
like,
sorry.
for me to, I can't even. Like,
It says while intoxicated. Well, they just throw her under the bus on the first question, don't they?
Fingers, stop it. I don't know how.
I get the shakes though. I don't know what that's about. I think maybe pain. I'm not sure.
Yeah, I get sweaty. I can't get the blue off.
Click on part of the white and it should get the blue off.
No.
Click off the screen.
I have.
Oh. Well, there, Jesus is holding it. It's good. It is alleged that on January 29, 2022, while intoxicated and operating, okay, can you scroll over a little or shrink? There we go. While operating her motor vehicle in Canton, Mass, the defendant, Karen Reed, killed her boyfriend, John O'Keefe. Wow, that's just so blatant. An off-duty police officer, which should have been said in the 911 call, but wasn't. Is there anything about the description of the case, the charges, or that victim was an off-duty police officer that causes you to believe that you cannot be fair and impartial in this case? Yes, no, not sure. Have you already started to make up your mind about this case? Yes.
Oh.
Do you have any opinions? Do you have any opinions regarding previous experiences as a juror, the fairness of the jury system and criminal justice? Wow, criminal's a hard word. Criminal justice system in our country that would impair your ability to be fair and impartial, both Commonwealth and to the defendant. Do you have any religious, philosophical beliefs that would make it difficult for you to follow the law and come to a verdict in this case? The case is expected to garner a significant amount of media attention. Is there anything about the high-profile nature of this case that would prevent you from serving as a fair and impartial juror? Do you have any family members? I know a lot of people that should answer this question. Do you have any family members or close friends reside in or conduct regular business in Canton, Mass? If the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because the witness is a police officer? That's a good question, actually. Conversely, would you tend to disbelieve a police officer simply because the witness is a police officer? Do you believe law enforcement officers are generally fair and accurate in their investigations? Normally. This case, however, has changed my mind. Do you believe law enforcement officers are generally fair and accurate in their investigations? Okay, I'm sorry. Do you believe, or do you have strong personal beliefs or have been exposed to any strong personal beliefs from friends and relatives about law enforcement officers, prosecutors, or the government? Again, I didn't used to, but you know. Have you ever been involved in a group, community, or individual activity showing support for law enforcement outside your own community? Yes. Have you ever been involved in a group, community, or individual that was critical of the police, law enforcement outside your own community? Yes.
Have you ever done a protest? More like it.
Yeah, I did a standout for Karen Reed in Charlotte.
Oh, did you?
I have, yeah. Have you or someone close to you ever had education, training, or work experience in any of the following fields: law enforcement, military, alcohol, drug abuse, domestic violence? Is that it?
Oh, it's white.
Oh, it's white. Yay. Do you want to read or you want me to read?
No, I'm eating olives.
Okay. Do you have any strong personal beliefs or have been exposed to any strong personal beliefs from friends and relatives about operating a motor vehicle while under the influence of alcohol? Thomas, okay, good. Have you ever been involved? You moved. Have you ever been involved in a group or organization participating in a march, demonstration, campaign, or donated money on behalf of an organization or cause that was against driving under the influence of alcohol, such as SAD, Students Against Drunk Driving, or MAD, Mothers Against Drunk Driving? Yes. Has anyone close to you ever been involved in an incident involving drinking and driving? Yes. Lost my uncle to a pregnant drunk driver.
Oh, really?
Yes. She was 9 months pregnant and drunk as a skunk. If so, would you experience prevent you from being fair and impartial juror? No. Have you or has anyone close to you been involved or witnessed a motor vehicle crash? Are you serious? The answer is yes from everyone.
No,
Everyone. You've never seen a motor vehicle crash? Okay. I thought everyone had seen one or been involved in one.
No.
Wow. Okay.
Never had one either.
I've been in several.
No.
Never one that was my fault, though. In fact, I was in Discord one time in a Discord chat, and I got bopped in the butt. I did, for real. Is there anything about crash reconstruction testimony that would make it difficult for you to be fair or impartial in this crash? Have you or family members or close friends been involved in domestic violence relationship that featured physical, mental, or verbal abuse? Yes, yes, and yes. Have you ever been a victim of a violent crime? I'm not going to answer that one. I'm not going to answer that. During trial, you will
rubbing me while I'm in hospital. Violent.
having to have reconstructive surgery, violent crime. During trial, you will hear testimony about medical treatment, death, and review graphic autopsy photos. Will that affect your ability to participate and be a fair and impartial juror? No.
Nope.
Do you believe Karen Reed should have to prove her innocence? No, because that's not how the law works. If the defendant doesn't testify, do you think she will probably be guilty or hiding something? No. Do you know or recognize anyone you have seen today in courthouse or in the jury pool? Yeah, didn't somebody in the courthouse kill somebody in a DUI? Just saying. Would you answer? Would your answer?
That blood that answers to Brennan is a dipshit.
Would your answer to any of the above questions be embarrassing or damaging if disclosed publicly, or would your disclosure infringe on your privacy? Do you have any concerns about your personal privacy due to the presence of video cameras in the courtroom and or a highly publicized nature of the case? Oh boy.
Do you have any of these?
I have to go on to my stream and delay it because it's scheduled for 5 minutes. So give me a minute.
So if they're just going for lunch now, they're going to be another 3 or 4 hours, yeah?
Yeah, I'm just gonna delay it.
Well, why don't we just do part 2 tomorrow?
We can. Are you exhausted?
I am shagged. Yeah.
Okay, that's fine. Dan, are you okay with that?
It's 3 a.m. here, and I.
Oh goodness, bless your heart. Okay, Dan, are you all right with that? Okay, I'll take that as a yes.
Yeah.
All right, guys. We'll do part 2 tomorrow. I'll stop it. I'll leave it stopped right there actually, and I'll just leave it pulled up.
Look, it's not going anywhere until Tuesday.
Yeah, the trial starts Tuesday, guys. Fat Girls, you'd love to. I'm glad that you're learning about the case here. And we'll answer any questions you have.
Yeah, write them down, and I'm more than happy. We're more than happy to answer them. Absolutely.
Absolutely. Yeah. All right.
And I'll have a few more presentations organized. I'm halfway through them at the moment.
People in my stream, you're going to be redirected to the stream that starts in 3 minutes. Okay, guys?
Just
all right.
redirect everyone. I'll redirect mine now. Hang on before you shut down.
Thank you. I appreciate that. All right. Until then.
Don't close. Don't close yet. I've got to redirect.
Just kidding. I gotta say, I'm worried about Karen because this trial has my nerves shattered. I just have a nasty feeling about it.
I haven't got you on here. I've got.
I can give you the link.
One you're in.
I can give you the
It's
link.
not body worn camera day, is it?
It is.
Okay, I got it.
Okay.
Save. Done.
Thank you.
All right. Until next time.
Watch out for those kangaroos. They like to box.
And until next time, stay the fuck away from Hank Brennan, America. See you tomorrow. Bye.
Bye.
It's been 12 months since acquittal, and so much has passed us by. such as tampering with evidence and some blatant flat-out lies. I bet he wears those silky undies, the ones with that jean made of lace. So you can bring in Massachusetts, 'cause we all ain't got no quit.